Hello, everyone, and welcome. This is Cecilia Friedman-Levin with Assista, and I am joined today by my wonderful colleague and coworker, Amy, and we are here to talk to you about assisting derivatives of U visa and applicants and VAWA self-petitioners. And I'm really excited about this topic and about this presentation today because I think it does deserve its own space. Oftentimes we talk about these forms of relief and we kind of talk about other family members and kind of just as on one or two slides, but I am really excited for the opportunity today to have a whole presentation about derivative family members, about children and how that connects with these larger forms of relief. And so today we're going to be covering some points here, talking a little bit about which family members are eligible for derivative benefits. I want to talk a little bit about roadblocks that can occur because anyone who has been a part of any family know that sometimes issues come up, right? And in this work, this is no different. We want to talk a little bit about strategies that can talk about consular processing, and then some ethical issues. What are our duties if we are helping family members, and what happens if there are conflicts? But before we begin and we dive in, Amy, do you want to introduce yourself and say hello?
Hi, sure. Thanks, Cecilia. Hi, everybody. My name is Amy Chung. I'm also with Assista. Thank you for the introduction, Cecilia. And I'm really excited to be doing this webinar as well with all of you. And I hope that everybody uses the chat box and feels comfortable participating and sharing their experiences so that we can all learn from each other throughout this session today.
Right, we really have a few polls for you lined up, and we really want to make this as interactive as possible. So if you have questions or you have comments or want to share your own cases or your own stories about working in conflicts and problems that can arise working with families, then we want to hear them because this is the space for that. So let's begin by talking about derivative eligibility for these different forms of relief. For the U visa context, the relationship for derivatives have to exist at the time of the filing of the application. And for who can be considered to be a derivative depends upon the age of the direct victim. If the direct victim is over 21, then you can have spouses and minor children as derivatives. The only kind of exception to that is if the spouse is the perpetrator of the crime, for example, domestic violence or sexual assault. The perpetrator of the crime cannot derive benefits if they were the ones who were the perpetrators of the underlying qualifying offense. And if you are under 21, you can include your spouse, minor children, parents, and also siblings under the age of 18. And so those are the family members who would be included as eligible U visa derivatives. So that relationship between the principal applicant and the family member has to exist at the time of filing an application. It has to continue to exist at the time they are adjudicated and at the time of admission. And so here when we're talking about admission, right, that's the both kind of physical admission if the derivative is abroad, but it's also kind of like through the grant of the actual visa itself if you are in the country. And so when we're talking about derivatives, we're going to talk about it in this case in terms of what is a child. A child is defined in the law under 101 B1 in the INA, which is unmarried, under 21 when the application is, not when the IA is filed, when the application under 21 when the principal's application is filed, right? So I think that we have a little bit of a typo there. So under 21 when the principal's application is filed, and has to remain unmarried until the grant of the actual U visa, or until they enter the country with U visa status. So that's what we're talking about in terms of the U visa context. For children, for spouses, that relationship has to exist up until the time that the actual U visa is granted. And we're going to talk a little bit about, in a moment, about what that means along the continuum. Because it's not that you file your U visa and then 6 months later it's approved. There's a lot of problems in terms of not only the processing delays that we're experiencing, which is currently, I think, about 45 months, before your even application is then put on the wait list. And then we have to consider the fact that a visa might not be available until several years down the road. So I think looking at these issues alongside the continuum of what the U visa process looks like is very important, because a lot of time is going to go by and people might have things that they want to do, or people's relationship status might change. And so I think that's why we want to look at this context kind of along the continuum and what those changes mean from the time that you're ready to file until the actual U visa is in hand. So let's go with our friend Susan. Susan is eligible for both U and VAWA relief. She has 2 children. Kevin is 2 years old. He's in the United States, but he was born overseas in her country of origin. Isabel is 19 years old, in the home country, and has her own 1-year-old son, Marco. Okay? So if we're applying for a U visa, and we can kind of have our poll, who is eligible to be the derivative? Okay? Again, we have Kevin, who is 2 years old. He's in the United States with Susan, but he was born in the home country. And then Isabel, who's 19, in the home country and has a 1-year-old son, Marco. So who is eligible to be derivatives? Again, this is all anonymous. We will not see who answers what, so definitely feel free to answer down. Okay, Kevin's in the U.S. Isabel is 19 years old, and Isabel has her own 1-year-old son, Marco. What do y'all think? All right, we'll give 5 more seconds. Okay. So, we have here that 91% said Kevin and Isabel only are eligible to be derivatives. Amy, what are we assuming about Isabel for her to be a derivative?
So keeping in mind the definition of a child who is under 21 but also unmarried, we know that Isabel's under 21, right, because she's 19, but we didn't say anything about whether or not she's married at this point. Right. So in order for Isabel to be eligible to be a derivative, we are assuming that she is unmarried.
Right. Excellent. We can close the poll, Alicia. Thank you. So we are making that assumption, right, that she's 19, that she's unmarried. And if that is the case, we have both Kevin, who is 2 years old, can be a derivative on his mom's application, and Isabel, who's under 21, also can be a derivative on the U visa application. But again, she has to be under 21, which she is, and unmarried. So we're kind of making that assumption here. But if she's married, then that would cut off eligibility, because then she would no longer fit in the definition of a child under the INA. But so we're going to talk a little bit about how we can help Marco in just a second. Now for VAWA derivative eligibility, It's children who are under 21 and unmarried. Again, they have to meet that definition under INA 101B1. And then what happens when someone turns 21? So the pivotal thing, I just want to go back for a moment to U visa derivative eligibility. The really pivotal legislation on this was VAWA 2013, which contained essential age-out fixes for derivative U visa applicants. So before VAWA 2013, U visa derivatives would have to remain under 21 and unmarried in order to become derivatives. And so what VAWA 2013 did is say that U visa applicants who are under 21 at the time of the principal's filing would continue to be classified as children, even if they turned 21 after the principal's application was filed. And this also talks about applicants who are under 21 at the time of filing. They should continue to be treated as a child applicant, even if they turn 21, to preserve their own parents and siblings under 18's ability to receive status as well. So there's this, VAWA 2013 contains really important age-out fixes to kind of freeze the derivative's age at the time of filing. So the important thing about VAWA 2013 is while it addressed the age issue, it did not address the marriage one. And so that's why I think that the question that Amy said about, we're assuming that Isabel is unmarried, is a really critical kind of second question to ask in addition to the age. So right, Leah, it's under 21 when the 918 is filed for the principal, not the 18. That was a typo. Thanks for catching that. So let's talk about VAWA. So VAWA, children under 21 and unmarried at the time of filing of the I-360. So like in the U visa context, the time of filing is really going to be, the age of the time of filing is important. So that's why as kind of a screening tool, when you're asking about children, make sure you ask that questions about whether or not a child is in the U.S. or back in the home country, and also find out those birthdays. Because if a child is turning 21, you're going to want to note that at the outset to see whether or not you're going to have any kind of timing issues as it relates to the filing. Both the Child Status Protection Act and VAWA provide age-out protection. It's with certain limitations, and Amy is going to go through those in more detail in just a minute. And to me, they're fascinating, but they're also really complicated. And so I think Amy is going to walk us through those and kind of all the considerations about the age-out protection in VAWA. In the U visa context, it's fairly straightforward. It's under 21 at the day of the principal's filing. But in VAWA, it can get a little messy. But it's really important that you remain unmarried through the admission. And so now we're going to talk a little bit about a poll about VAWA. So if Susan is applying for VAWA, who is eligible to be a derivative? Our 2-year-old Kevin, 19-year-old Isabel, and maybe 1-year-old Marco, Kevin and Isabel only, or Kevin, Isabel, and Marco. Everybody together. Okay, so we're right. So Kevin and Isabel, right, like in the U context, can also be derivatives on mom's application, right? Because as far as we know, they are both under 21 and they are unmarried. But then we have poor baby Marco, and we're going to talk a little bit about what to do with him in the next couple of slides. But for direct derivatives of these applications, what you're looking for is that they're under 21 and unmarried at the time of filing. And for the U visa context, that has to continue, at least the unmarried part is critical for both of these forms of relief. And the age out, at least in the VAWA context, requires some math, which we'll get to in a moment. Okay, so we can close this slide, and now we have a series of polls on this next one. Okay, so our scenario was this. If we can just pause it for a second. So Susan decides to file for a U visa, listing Kevin and Isabel as derivatives. But Isabel, without consulting you, got married. Okay? So the poll question one is this going to be a problem for Isabel to get U visa derivative status? You can open the poll now. Is this going to be a problem if Isabel gets married? Okay, so yes, this is going to be a problem. If she gets married while this application is pending, then they're no longer considered to be a child under INA, under 101B1, right? Because you have to be unmarried. VAWA 2013 fixed the age, but did not address any kind of marriage issue. So if Isabel gets married while the application is pending, that could potentially cut off her eligibility to become a U visa derivative. Now we're going to go to the next poll. Now let's say that Isabel got married while Susan is on the wait list. Is this going to be a problem for Isabel to get U derivative status? Right, so we're just waiting for a U visa to be issued. But we have deferred action. Or no, she's in the home country, so she doesn't have deferred action. But mom has deferred action. Right. So this is going to be a problem for Isabel if she gets married. Because while you're on the wait list, you don't have a visa in hand. So that's why it's really important to kind of advise people, even though this is going to be a very long road, that the effect of marriage while this application is pending, the effect of marriage while a case is on the wait list is going to matter. And so it's going to be a problem for Isabel to get U derivative status if she gets married because she's no longer considered to be a child. Now we have the next poll. What if Isabel got married after she entered in with U visa status? Is this going to be a problem for her? So she has a U visa, she consular processed in with a U visa, then she got married. Right. So here we have, most people said that no, that she wouldn't, and this is correct. Because if we go back to the eligibility portions, we can close the poll. That you have to remain unmarried through the admission in U status. And so what USCIS has said is that once you have the full 4-year U visa and you decide to get married, that kind of completes the admission. There is no requirement that you have to remain unmarried for the time of adjustment. So generally speaking, the USCIS will not revoke U3 status. They will not have any trouble at the time of adjustment if the U3 gets married after they have the full 4-year visa. Okay. All right, so now the last poll question, if we can pull that up, Alicia. What if Isabel got married after Susan applied for VAWA, which should be eligible to consular process as Susan's derivative? Right. Again, that would cut it off. And so there's this really interesting conversation that's going on in the chat, and I just want to take a moment to talk about that. So if we're talking about eligibility, right? And so if Isabel got rejected because she got married and was no longer eligible, then that would, if an application is denied because you don't have the basic eligibility, then there's a potential that that NTA memo would come into effect. But again, we do not have the operational guidance, and so the NTA memo has kind of been pending until that operational guidance from USCIS comes into effect.
I also think it's important to distinguish between rejections and denials, because the NTA memo spoke specifically about denials, and if Isabel, let's say, filed for adjustment as the derivative on her mother's, or she was filing for her 918A, she was in the country, and the 918A was denied because she was married, denials would fall under the NTA, but rejections actually aren't discussed in the NTA memo at all. So I think we don't actually know exactly what would happen with rejections.
I think yes, and we don't know, right? We don't have these operational guidance. The NTA memo does discuss withdrawals and withdrawing applications in the context of fraud or misrepresentation as being a triggering event, but I think that's why we're kind of waiting on that operational guidance to get more sense of it. But the other thing that I want to mention here that I think is really important, because there are two BIA cases that I think are worth kind of having in your back pocket when you are talking about these cases. One is called Matter of Aldeco a la Talora, which is a BIA case from 1983. And I'll put these citations in the chat box once Amy's kind of talking about the next part of it. And then there's Matter of Wong, which is a BIA case from 1977. And these cases, I think, are important because when we're talking about unmarried, right? And so if we're thinking about marriage in terms of what that means in the INA, and so, you know, is someone who is divorced no longer married? Yes, according to the regulations, that's true. But these cases are important because they talk about what they had. We've heard of kind of like sham marriages. BIA also has case law on what they call sham divorces. So these two cases, Matter of Aldeco a Talora and Matter of Wong, talk about that. So where the beneficiary is divorced for the sole purpose of obtaining an immigration benefit, that divorce is considered to be a sham and is not acceptable for immigration purposes. And similarly, this case is a Matter of Wong from 1977. You know, it was a case where a person entered the United States as an unmarried daughter when they were actually married. And so later she got an annulment because she wanted to show that the marriage was void, so she can kind of be in the same legal position as if she were before. But the BIA decided not to relate back the annulment because that would be perpetuating fraud. So I just think it's important to kind of distinguish, like, oh, will a divorce kind of, quote, cure these situations? And the answer is the same way you can't have a marriage that is for an immigration benefit, that you also can't have divorces for the sole purpose of obtaining immigration benefits. So I think that this kind of leads us to different situations. For example, if there is a divorce, so if Isabel gets divorced and she's still 21, maybe you would kind of withdraw that other Sup A and then maybe submit a new one if they're still under 21. And so I think it's important that if you do see these and people are like, oh, we'll just get divorced, that there is important case law on the issue of sham divorces for purposes of obtaining an immigration benefit. The question comes up if Isabel's U.S. got married after being waitlisted. I think this would also be an issue with the grant of the U visa, because in the issue is that you have to remain unmarried until the grant of the U visa. So I think that they could still have an issue. But if she gets married after the U grant, I do not see this causing a problem with the adjustment. And so another question that was asked, if Isabel got married after being admitted to the U.S. under VAWA, would that affect anything if she consular processed in under VAWA, Amy? What do you think?
So the thing to keep in mind under VAWA is that when you consular process in under VAWA, you're being admitted as a lawful permanent resident. You have a green card, right? And at that point, you don't need to maintain any other relationship to the principal. So you don't have to be a child anymore after you've consular processed. And so marriage at that point shouldn't affect her at all.
All right, great. So we're going to end these slides. Thank you so much, Alicia. What are we going to do with poor Marco? So Isabel's okay and Kevin's okay, but we have Isabel's son. Like, what are we going to do? Is there anything to be done? And so generally speaking, grandchildren of principals are ineligible for derivative status through VAWA or for you. So your options are that you might do a family petition by a parent once they are a legal permanent resident, or consider an application for humanitarian parole. And so this is a case in which there's been several success stories, but the use of humanitarian parole for these grandchildren. And we're going to talk about some important caveats from this. And so you derivatives might be eligible for parole once the principal gets on the wait list. And I have heard of some cases, again, this is not a promise, but there's some cases where you can actually try to get an expedite, if there's an emergency situation with a derivative, to try to get the application expedited. These expedited requests are done on a case-by-case basis. And so usually there is some kind of very urgent need, maybe some kind of severe illness or sickness, or a very emergent situation in the home country. So that a humanitarian parole might be an option for these derivatives once principal is on the wait list for the U visa. And so we're going to talk about parole. And the key statute to remember here is INA 212-D5. And so this is that parole to enter the United States is necessary for urgent humanitarian reasons or to prove a significant public benefit. These decisions are made on a case-by-case basis. And so I think that you can arguably show that both VAWA and the U visa itself provide a significant public benefit. You can talk about that Susan was a victim of a qualifying crime, the cost and the toll it took for her to be involved in a criminal investigation or prosecution, and also show the urgent humanitarian reasons for this family reunification. Does Marco have anybody else in the home country that can take care of him? Are there any other kind of emergency circumstances that would be necessary to show, is there any kind of threat to the family that was going on in the home country that would have this need for Marco to travel with his mother? And so if we say, for example, that Isabel would be eligible to come in as a derivative, right, as a U3, then Marco would be able to enter from a humanitarian parole application for that family reunification purposes. So in this case, we would try to get Isabel to come in on a U3 visa, but we would apply potentially for parole for her 1-year-old son. And so you can have a fee, or there's a fee waiver. The affidavit of support, the I-134, is required. And it'll give you, parole is valid for up for 1 year. It can be extended. And if we're looking at it in the U visa context, right, there is a regulatory directive in this citation in 214.14, in 8 CFR 214.14D2, that says that once cases are placed on the wait list, that USCIS shall grant deferred action or parole. And so we have been doing some advocacy that talked about whether or not there's going to be establishing a parole program for the U visa applicants, and that is not the case. And so what we have now is statutory 212D5 as an option to potentially have a family unification for Marco. This is not a guarantee. This is something that I think people can try, but you have to, and we do have some materials that we can share if you have this situation that we can share with you as templates if you reach out for us to technical assistance. And so we're asking some really great questions about permission, right? Does Marco, would he need a passport to travel? Can he get one? Exactly. All of these issues are going to come to play for this consular processing. You know, does Isabel have full custody of Marco? Otherwise, do we need an affidavit or some other kind of documentation that Marco's parent consents? All of that would have to be figuring out in order for Marco to enter this country. Amy, is that anything you would add to that?
Just a couple of things. So as Claudia mentioned, a lot of the same considerations that come up in consular processing in other contexts like DNA testing, permission to travel, obtaining a passport, a lot of those same considerations are going to come up in the humanitarian parole context as they do in other consular processing contexts. There's nothing about humanitarian parole that's going to allow somebody to avoid those kinds of issues necessarily. And I also think it's really important to keep in mind that even if you're bringing in Isabel and Marco on humanitarian parole, if, let's say, Isabel is a derivative on a U visa, the idea ultimately is that she's going to get an I-918A approved and she's going to be a U3, right? But Marco is not going to get a U visa in that way, right? He is still going to have to in order for him to remain in lawful status in the United States, he's going to need some other way to stay here. And so typically what you're looking at is for Isabel to adjust status and get her green card and file an I-130 for Marco down the road.
Thank you, Amy. That's really important because I think that there's kind of two steps to this process that I can make a little bit clearer. One is considering parole for Isabel and Marco while Susan is on the wait list, right? And I think that that is something kind of given the fact that a visa might be several years out for Susan, that if there is some kind of emergent need, then you would get both of humanitarian parole applications for Isabel and Marco, right? But then if we come to the time where maybe a U visa is available for Susan, and so Isabel is able to kind of go through the whole process of being able to consular process into the United States, that still leaves Marco with an option. And the only option for Marco, even at that point, if mom enters in as a U3, would be parole. And so I think we can look at parole for both of them if mom is on the wait list. And if mom has a U visa, then Isabel can come through, but parole would conceivably be the only way for Marco to join at that point as well. Did I kind of capture that, Amy?
Yeah.
Awesome. All right, we're going to talk a little bit on this next slide about logistics. It's always better to file the supplement A's with the principal's application. That keeps all the paperwork together. That kind of keeps the family together, kind of all in the same rubber band of files. So there might be circumstances in which, especially if a derivative is abroad, it's hard to do at that time, especially if you're running into kind of other deadlines with the U visa. So you can file it in after the time of the principal files as well. Or until the time that they're ready to file for their adjustment. But it's also the case that they usually kind of adjudicate these cases in last in, last out, or kind of the opposite of that, first in, first out. And you really want to make sure that you kind of put the entire packet together for the family as early as possible, right? And derivatives cannot enter until they have the U visa, till the principal has their U visa. And at that point, they can begin the process for putting all the documentation together to come into the consulate, right? And then the very important part of this is that the principal must not adjust until the derivative is entered in under U3 status. There is potentially another way through the 929 qualified family member process that a derivative who never had U status might come in, but there is an age out limit for that process for the 929 qualifying family member application. So those derivatives must be under 21 at the time that they enter into the United States, which is why coming through under U visa derivative provides more protection. You don't want to wait until it's further down the road and then the derivative is too old to come in any other way. So the principal must not adjust until the derivative comes into the United States with U status. At that point, the adjustments are treated independently. And so mom can adjust whenever she has her 3 years. The child can adjust whenever they have their 3 years. But if mom adjusts before the derivative comes into the United States with U status, then that cuts off the derivative's eligibility to enter in as a U derivative. For VAWA, the triggering document that kind of gets the consular processing started for derivative abroad is the 824. And if you're filing a one-step application, so if you're filing for the I-360 together with an application for a green card, the 485, you can file that 824 together with everything. So your I-360, your I-485, and you can include the 824 with that, so that that form can be worked upon the approval of the adjustment application. But if you are filing based on a two-step VAWA, so you're filing for the I-360, you wouldn't file the for example, if the abuser was an LPR, you couldn't file that document, the 824, until the principal is ready to adjust. And so that is so you would put the 824 together with your 485. And so if your abuser is a USC, you can do that together all in one fell swoop. But if you need to space it out because the abuser is a legal permanent resident, you would file that document, which is a notice of action on an approved application. You would file that together with the 485. And in the VAWA context, the derivative cannot consular process until after the parent has their green card. And the consular processing can take probably every year. And if the abuser is an LPR, then you need to really kind of watch out for age-out protection, or age-out issues, which I think Amy is going to dive into with much excitement on this next slide.
I am very excited to talk about the age-out issues for VAWA.
I wasn't joking.
It is, I kind of a love-hate relationship with these issues, but I think it's endlessly fascinating. Before we get to it, though, I do see one last question on the humanitarian parole and where it should be filed. So if you look at the filing addresses and the directions on the Form I-131, it tells you where it should be filed. I've always filed my humanitarian paroles first with the service center. I believe it was the Texas Service Center, and then from there it would be routed to the Humanitarian Affairs Branch of USCIS, which is located in DC. Cecilia, I don't know if you have different experience with that.
Nope, that's right. I think for a while people were filing them with Vermont, and they would sit there forever. So I would follow the instructions on the form.
Okay. All right, moving on to age-out issues. So as you guys have all heard already, typically for U visas, especially for derivatives who are coming in under a 918A, you don't really need to worry about age outs because as long as the derivative was under 21 when the principal filed the 918, their age was preserved. For VAWAs, it's not that simple. And so we're going to be spending the next segment of today's webinar talking about age out issues, especially in the VAWA context. And so the age outs in the VAWA context differ depending on a number of factors. And when we're talking about age outs in VAWA, we're really talking about two legal provisions, one being the Child Status Protection Act, also referred to as CSPA or sometimes CISPA, and then also the Victims of Trafficking and Violence Protection Act, or the VTVPA, which provides some additional protections for VAWA derivatives. And we're going to start off with the CSPA because it's broader, it's more general, and it's more protective. And then we're going to be speaking about the VTVPA a little bit later and how it can kick in where the CSPA has not protected your derivative from aging out. So when we're talking about the CSPA, there are various factors that are going to determine whether or not the derivative's age is protected or not, because the CSPA will not necessarily protect derivatives from aging out. And so the factors that we're looking at include the status of the abuser. Was the abuser a U.S. citizen or a lawful permanent resident? How long was the I-360 pending at the Vermont Service Center? How old was the derivative at the time of filing? They needed to be under 21. But also, how old is the derivative now? And you're also looking at what country your derivative is from. What is their country of chargeability? And then if you look at the authorities down here, we really encourage you to read the Yates memo because it lays out in a lot of really helpful detail how the CSPA and the VTVPA intersect to protect VAWA derivatives from age out. So let's walk through these factors and take a look at what they mean in this context. So when the abuser is a U.S. citizen, this is what you're always hoping for. This is the easiest way to go, and it's the simplest in terms of figuring out whether or not your kid's age is protected or not. So let's say Susan's filing for VAWA, her derivatives are Kevin and Isabel, and she was married to a U.S. citizen. This means that when Susan files the I-360, her children's ages, both Kevin and Isabel's, will be frozen as of the date of the filing of the I-360. So this means that as long as Kevin and Isabel were under 21 when Vermont received that I-360, their ages are frozen and they're not going to age out. And this age out protection continues all the way through to when they get their green cards. So for Kevin, when he's in the United States, so even if he turns 21 before he gets his green card, it's okay. For Isabel, she's consular processing. Even if she turns 21 before she finishes consular processing and enters the U.S., it's still okay. As for U visas, though, keep in mind that the CSPA will only protect their age. It does not protect their marital status. So if Kevin or Isabel got married, they would not be protected under the CSPA in terms of their marital status. So they would still lose their derivative eligibility even if their age is frozen. All right, so now let's move on to the more complicated situation. It all changes when the abuser is an LPR. And so when the abuser is an LPR, the derivative's ages can still be frozen. They can still be protected from age out under the CSPA, but you have to look at a lot more factors and there are more steps. So the general rule is going to be that the CSPA will freeze the child's age, but it's not frozen as of the date of the filing of the I-360. Instead, it's frozen as of the date that the visa, the immigrant visa or the green card, became available. And we're going to talk about what becoming available means. And it's only going to freeze if, as of that date, the child's CSPA age is under 21, and also the derivative has sought to acquire permanent residence within 1 year of the visas becoming available. So we have a whole lot of terms of art here. Yep, go ahead.
Yeah, so I think that when I look at this, it's kind of three components. So the date the visa became available, like became available is a specific term that has meaning, which you're going to get into, right? And that becomes available once the CSPA age, and so if we're looking at kind of that there's this equation, right, that you have to kind of consider. So that became available is like a term of art.
Right. So we're going to be talking in the next few slides about what it means for the visa to become available, also what the CSPA age is, and also what it means to seek to acquire permanent residence. But it's important to keep in mind what the general rule is so that when you're looking at the specific terms, you can see how they fit together in the puzzle. All right. So let's look at what each of these terms means. When we say CSPA age, we're not talking about the person's biological age, right? We're talking about how old was the child when the visa or the green card became available, minus the number of days that the I-360 was pending, right? So here is one of your equations that you're looking at. So when you're looking at how old your child is under the CSPA, you have to have a number of dates. You have to know their date of birth so you can calculate how old they are. You need to have the date that the visa number became available, which we'll be talking about in just a second. And then you also need to look at the number of the days that the I-360 was pending at Vermont. So that's the date that Vermont received the I-360 until the date that the I-360 was approved. And when you subtract the amount of time that the I-360 was pending from the child's age when the green card became available or when the immigrant visa became available, that's when you get the CSPA age. And you're looking for the CSPA age to be under 21. If your CSPA age is over 21, your child has aged out. If it's under 21, your child still has a chance of being protected from aging out. And then what does it mean to say that a visa number has become available? So a visa, so the issue is that the immigrant visa or the green card is not immediately available to children of LPRs, right? So I'm sure a number of you guys have done family-based immigration before. For anybody who hasn't, the issue is that under the family-based immigration system, only certain relatives like spouses and minor unmarried children and parents of U.S. citizens over 21 are immediately eligible for a green card. They're the only people who don't have to wait in line. Everybody else, including spouses and unmarried minor children of LPRs, have to wait in line for an immigrant visa or a green card to become available in order for them to immigrate to the United States. And so they're waiting in line for a really long time until a visa has become available. And the issue is that the number of visas available in any year are limited. And so if you have more people applying for visas than there are available, then that creates a waiting list. And there's been a waiting list for many, many years. And so there is a significant amount of time that spouses and minor children of LPRs have to wait in order for their visa or their green card to be available to them. And every month, the Department of State publishes something that's called the Visa Bulletin. And this Visa Bulletin, I'm going to put the URL in your chat box here. And the Visa Bulletin is what tells you whose visas are available. And you check it every month to see and then you look for the category for your client. The government has split up the different types of familial relationships into different types of categories. So F2A is a category for spouses and minor unmarried children of LPRs. And so if we're looking at the VAWA context, we're primarily looking at the F2A category here. And then you look at the box for F2A, and then next to it, it gives you a date. And so right now for August, the date for F2A is July 22nd, 2016. What that means is that, for example, let's say the I-360 was filed on July 21st, 2016. So the I-360 was approved a long time ago, but the F2A category wasn't current yet. Now, all of a sudden for August, the date on this bulletin is July 22nd, 2016. That means that for everybody whose I-360, or more generally speaking in the family-based context, I-130, whose priority date or date of filing was July 22nd, 2016 or earlier, their visa is available. But if their filing date was, let's say, July 23rd, their visa is not available yet. So going back to this question of when the visa number is going to become available, you're looking at this visa bulletin to see if their priority date is current, right? And so what you're looking at is, has the I-360 been approved, and also, is the priority date under category F2A in the visa bulletin current? And you're looking, and the visa is going to become available when both of these things are true. So typically what we see is that the I-360 is approved, and then you have to wait a while for the F2A category to become current. And so the visa becomes available when the F2A category becomes current. But there are times when the priority date is already current when the I-360 is granted by Vermont. And in that case, then the visa would become available when the I-360 is approved. So the visa becomes available whenever both the I-360 has been approved and the priority date is current. Cecilia, did you have anything to add there?
Oh, no, I think it's good. I think, yeah, we're on track.
Great. Okay, so if we go back to our general rule here, right, we're looking at the CSPA age and the date that the visa became available, right? And so if the derivative CSPA age is under 21 on the date that the visa becomes available, right, then you want to freeze that age. And you freeze that age by seeking to acquire permanent residence within 1 year of that visa's becoming available. Okay? So let's say that going back to this month's visa bulletin, let's say that this visa became available on August 1st, 2018. Okay? And so you then would need to seek to acquire permanent residence within 1 year of August 1st, 2018. And you seek to acquire permanent residence by filing an I-824, an I-485, or a DS-260. Any of these things will satisfy the seek to acquire requirement. The thing to keep in mind is that even if you do the CSPA age calculation, the visa becomes available, and the CSPA age is under 21, in order to freeze that age, you have to seek to acquire within 1 year of that visa becoming available. If you don't satisfy that requirement, if you don't file the I-824, the 45, or the DS-260 within 1 year of that visa becoming available, the age will not freeze. And that's something that's really important to keep in mind, because sometimes we see sometimes young children who are going through the consular processing process, and perhaps the representative is thinking that, oh, there's plenty of time, we don't need to seek to acquire because it doesn't matter if the child's age freezes. But as we know in the consular, when you're doing consular processing, anything can happen. There are all kinds of things that can cause really severe delays in consular processing, whether it's on the part of the client or on the part of the government. And so it's always a good idea to satisfy all of the requirements under the CSPA to freeze the child's age. And so we always recommend filing the I-824 with the 485, with the principal's 485, and to take care of that as soon as possible.
So Amy, how do you recommend kind of keeping track of all of these dates? Because it sounds like there are certain benchmarks that need to be hit, right? Like in terms of the approval.
Mm-hmm.
So what are kind of like those benchmarks that people should kind of look out for if this is kind of on their radar screen?
Yeah. So this is something to screen for when you're taking a VAWA client where the abuser's in LPR, right? If you have derivatives who are on the older side, this is something to be aware of right away, to know, to flag for yourself that you should be filing this I-360 as soon as you possibly can. It's also something where you need to be talking with your principal client about the possibility that the child could age out depending on how long everything takes, and there's no real guarantee that the child is going to remain eligible to derive status through this petition. In terms of keeping track of dates and deadlines as you go, I think every practitioner has their own methods of keeping track of deadlines. We all have tons of deadlines on every single case. Some people use case management databases and tools to flag deadlines for themselves, to set up alerts for themselves, a few weeks before any kind of deadline and things like that. But the key deadlines are always going to be the age of the child. When is the child turning 21? Every single month when you have these kinds of cases, once the I-360 has been approved, you need to be checking the visa bulletin every single month to see if the F2A category has become current. Because once the F2A category has become current, that's when you want to file the 485 and the I-824. And you want to do this as soon as possible. They give you a year, but you don't want to take the year for reasons that we'll be talking about in just a minute. There's really no reason to procrastinate on this kind of issue, and you want to file it as soon as possible to give your derivative the best chance of not aging out.
And generally the priority date is the date of filing, right?
Mm-hmm. Yes, the date of filing of the I-360.
Right. And sometimes that can be recaptured, for example, if you have an I-130, but generally speaking, if nothing else has been filed, the priority date will be your date of filing.
Yes.
Okay.
And then one other cautionary note here is to watch out for priority date retrogression. And so this is one of the reasons why it's so important to file the Principals 485 and the I-824 as soon as the F2A category becomes current. Because the issue is that the Department of State is the one who's issuing the visa bulletin. They're the ones who are figuring out how many visas are available and doing the math to figure out how many more visas they can issue this month or this year, and that's how they set the priority dates. It's based on a prediction of how many visas are going to be available. And so the issue is that sometimes DOS has incomplete information about how many visas have been issued and thus how many are available. And if they're wrong and they may have issued too many visas the month before, then that means that for the next month they might push the date back. Typically these priority dates are going to move forward every month, but when they have retrogression, they're moving it back, sometimes by weeks, sometimes by months, sometimes by years. And you don't always know when this is going to happen. They do tend to issue some kind of note about this, but you don't always know, and you don't always know how much it's going to retrogress. And so if your child is on the older side and you haven't filed the I-824 and then the priority date retrogresses, then your child is going to continue to get older and older and older because the age has not frozen. The priority date is not current. The visa is no longer available. And so this is one of those things where even though you do have a year to file the I-824, you don't want to wait that long. You want to do this as soon as possible. All right. Next up, let's try to make this a little bit more concrete. So let's say that Susan files for VAWA as the abused spouse of an LPR, and Isabel and Kevin are her derivatives. And she files this I-360 on January 1st, 2017. So her priority date is January 1st, 2017. And when she files the I-360, Isabel is 19 years old and 2 months. Okay. All right. So then the I-360 was pending, let's say, for 1 year and 3 months or 455 days. We all know I-360s are taking longer and longer these days. Maybe there was an RFE. So it took 455 days for Vermont to adjudicate this, right? And so it was approved on April 1st, 2018, at which time Isabel was 20 years and 5 months old. The problem is that on April 1st, 2018, the F2A category was not current. Her priority date was January 1st, 2017, and at that point, it was not current per the visa bulletin. And so they had to continue to wait. And the priority date did not become current until January 1st, 2019. And I'm making all these dates up, right? Don't look at the visa bulletin to try to figure out whether or not this was true. So we're saying that on January 1st, 2019, F2A becomes current. And at that point, Isabel's age is 21 years and 2 months. All right. So now for the chat box. On what date did the visa become available? And we only have 3 options here. Your choices are January 1st, 2017, April 1st, 2018, and January 1st, 2019. What date did the visa become available? Great. So we've got a consent on January 1st, 2019. That's right. So January 1st, 2019 is the date on which the F2A category was current, the priority date was current, and also the I-360 had been approved. Okay, so now the visa is available, and we're going to try to see what Isabel's CISPA age is to see if she has aged out or not. Okay, so now we do our calculation. So her CISPA age is going to be her biological age, which is 21 years and 2 months, minus the number of days that the I-360 was pending. It's 455 days. I changed it to years and months just to try to keep our units consistent. But it is the number of days that the I-360 was pending. And so her CISPA age is 19 years and 11 months. And so you can see here what CISPA does, right? And so her biological age was 21 years and 2 months. If we didn't have the Child Status Protection Act, she would have aged out already. But because we have CISPA, we get to subtract the amount of time that the I-360 was pending, and that makes her CISPA age younger than her biological age. And so she's only 19 years and 11 months. And so as long as we can freeze that age, she is not going to age out. Okay? And so as long as she seeks to acquire permanent residence, that means filing the I-824, the 45, or the DS-260 within 1 year of the date that the visa became available, which is January 1st, 2019, that is January 1st, her age will freeze at 19 years and 11 months. Okay. Now let's see what would happen if we made Isabel just a little bit older. So let's say that when Susan filed the I-360 in January 2017, Isabel was already 20 years and 10 months. So if Susan had been married to a U.S. citizen, Isabel would be free and clear, right? Because she was under 21 at the time that the I-360 was filed. But here, because the abuser was an LPR, we have to go into CISPA. So the I-360 takes 455 days for Vermont to approve. It's approved on April 1st, 2018. Older Isabel is 22 years and 1 month old. And then the visa became available on January 1st, 2019, when the F2A category became current. And at that point, Isabel was already 22 years and 10 months old, right? And so now we're going to apply the same formula for calculating her CSPA age. So it's her biological age, which is 22 years and 10 months, minus the number of days that the I-360 was pending, 1 year and 3 months. And so now her CISPA calculated age is 21 years and 7 months. And so since it's over 21, that means that Isabel has aged out. And so what that means is that it doesn't matter if she seeks to acquire, she's aged out. And so the Child Status Protection Act is not going to protect her. Okay? But she's not out of luck. So when a derivative has aged out, this is when we look to the special protections for VAWA derivatives under the VTVPA. And so there are particular provisions in here that will protect children and derivatives who have aged out and for whom the CSPA does not provide protection. And so here, if a derivative has aged out, they could still come to the United States. They could still adjust status if they're here. They could still consular process down the road if they're abroad. But the way that they're going to do this is a little bit different. So initially, remember that Isabel was under category F2A on the visa bulletin because she was the minor unmarried child. She was considered the minor unmarried child of an LPR. Now, because she's over 21, she's not considered a child of an LPR anymore. She is the unmarried adult daughter of an LPR. And the category for this type of familial relationship is going to be F2B instead of F2A. And so her category is going to automatically shift from F2A to F2B. And then she's considered a self-petitioner in her own right, but she does not have to submit an I-360. And also she's going to retain the priority date of her mother's self-petition, which is January 1st, 2017. And so what this means is that you're going to continue checking the visa bulletin every month to see when the F2B category becomes current. And you're going to be checking it based on the priority date of Susan's petition, January 1st, 2017. And this should allow Isabel to have a visa available to her earlier than she would if she had had to submit her own 360. And like for any other VAWA self-petitioner, there's no requirement for an affidavit of support. And then once the F2B category becomes current, then she can consular process. If she's in the United States, she would be able to get deferred action and a work permit until the F2B category is current, at which point she would apply for adjustment of status.
Right. So, Amy, if we kind of take a look at the visa bulletin that you had just posted for this month, right, and kind of looking at the difference between what F2A and what F2B looks like, pulling that up, it is, definitely, I think, a few years of a differential.
Yeah, you're looking at about 4.5 years. So it's a significant wait. And so, ideally, we would always want the CSPA to be what applies in these cases to protect age outs. The VTVPA is not nearly as protective, and it's not nearly as desirable because they're going to be separated for a much, much longer period of time. But eventually,
it's something.
She would be able, you're right, it's something. It's better than nothing.
I'd like to, if we can, get to Kathleen's question, which is what if, say if we could go back to Isabel when everything was copacetic. Okay. So she has to seek to acquire. So Isabel seeks to acquire. She files the 824 within that year. But after that has not followed up or done anything in the interim. Is the age still frozen? If the act is,
yeah. I haven't seen that particular situation, but I think it would be. Because I don't think that there's any language requiring follow-up. It seems like once the age is frozen, the age is frozen. Cecilia, I don't know if you've seen anything different or if any of our participants have seen anything different on that point.
No, I think I haven't, because I think, what we have in the law is kind of what Amy had put back before and what kind of seeking to acquire means, right? And that there's options for what that means, the 824, the 485, the DS 260. And that, to my mind, would be kind of the last thing you need to do to complete that equation, to freeze the age. But if you're running into any issues, Kathleen, I'm sure that we would like to hear about them. All right.
Great. Okay. So, Cecilia, you're up.
All right. So now we're going to talk about kind of some troubleshooting some issues, particularly in the context of consular processing. And can I just get a raise of virtual hands and how many folks have done consular processing for you or VAWA applicants abroad? Can you raise your virtual hand? Okay, so Carly, Leah, okay. Okay, so we have just a few of you who have, and I'm sure that all these people, Kathleen, Eric, and everyone can tell you that it can be kind of complicated and kind of getting everything in order to make sure that you're dealing with different consulates. Consulates have their own rules, their own procedures, and so these are just some of our kind of tips, and if you have others, we would love to hear them on kind of how to troubleshoot these issues that you might come across. And so again, as with our advice on, oh, where'd it go? See that? Alicia?
We have a runaway slide presentation here.
A runaway slide, okay. Well, I will just tell you what the slide says, and you can just imagine it virtually. An ounce of prevention is worth the pound of cure, as they say. And so I think that what we want to do in terms of ensuring that there's a consular process goes as smoothly as possible is to, especially if we're dealing with issues of inadmissibility, that all of those come out up front in the 192 context for derivatives abroad. And so some common issues that might come up include prior removals, included expedited removal, if they had by leaving triggered unlawful presence, a lack of documentation, maybe the inability to get a passport, and also if they had any criminal issues, including crimes involving moral turpitude or drug issues. And so all of those, I think, are going to want to be addressed at the outset. And it's important when you are doing your 192s that you include the full citation of what you want waived. In the consular processing setting, we have seen things kicked back because the little I or the little 2I is not checked off. And so you really want to make sure that everything that needs to be waived is waived, including the full citation. And so if the consular official finds additional grounds, they're going to need to file a new I-192 with USCIS. And so here, I think we really want to kind of emphasize that it is all about discretion. You know, discretion, discretion, discretion. And so to the extent that there are compelling circumstances that will require entry abroad or their own community involvement or involvement with their faith-based community, then I think that is something that is going to be important to put in the 192s. And I think that similar to what we would show in like a good moral character component for a VAWA application, that type of evidence is submitted with the I-192 waivers. Excuse us, I'm trying to see if there's anything that we need to do. Oh wait, it's coming back. See, we just needed to like give it a hot minute and then it was fine. All right, wonderful. So here we are, proving this relationship. Sometimes that can be a lot harder than the initial, than initially thought out. Maybe because there's information missing in the birth certificate, or it's incorrect, or maybe it just has never been issued. And then those are instances where they're going to want to see potentially a DNA test or something that is a little bit more costly to prove the relationship. Amy, have you ever had to do a DNA test for one of your clients?
Unfortunately, yes.
Oh,
yeah.
What was that like?
Yeah, and it was a case where the birth certificate had all of the correct information, and they still wanted a DNA test anyway. So it's doable, but as Cecilia mentioned, it's very costly. It's time consuming, and it's logistically it can be a little bit complicated to coordinate DNA testing in 2 countries at the same time. But it's not that uncommon for it to come up.
How did you do that? Was there a list of agencies in the home country that you had to contact?
I believe there was. I mean, it was a while back, so my memory could be a little bit fuzzy. But I believe that there were, certain facilities overseas and then certain facilities in the U.S. That could do the DNA testing. And then so it worked out, but it's one of those things where it's anytime you're consular processing, it's a possibility.
Right. And then in terms of other relationships, like say you have a U applicant with a spouse abroad, they're going to want to make sure that that marriage is valid. If they were married before, they're going to want to see divorce documents. And Amy and I think, saw recently that they wanted divorce documents even though there was no actual relationship between, it was a step-parent, and they wanted to see kind of the viability of that relationship even though it had no bearing on the relationship between the mother and the child. And so sometimes they just ask for things that really are not germane to the underlying case. So sometimes it happens that maybe you've inherited a case and the number of children that are listed on the application is not the actual number of children that the applicant has. I don't know if this has ever happened to people. And so sometimes I think there might be some confusion that the applicant might think the children that they should have listed is only the children that were in the United States. And so how have people dealt with this, if they've had to deal with this? I'll see in the chat box if anyone has had to have this happen. Oh, I see some other questions too. So what we have seen here is, I think, that is a matter of amending the application, right? So you might need to submit a Sub-A for a U visa applicant. For the context of an I-360, you might just have to write Vermont with an amended I-360 with an explanation that perhaps the client didn't understand the question initially, and that here is the birth certificate or additional information for derivatives who they would want to include as a derivative on the application. Generally speaking, I have seen this in the VAWA context be corrected without any kind of difficulty. Amy, have you had other experiences?
I haven't. I agree that in the VAWA context, it hasn't been too difficult to amend to include additional derivatives.
Right. And so here is where things can get really sticky, particularly since I think that we had someone mention before about whether or not Marco could even travel if we got humanitarian parole. And I think that is something that we would try to get, first of all, waived. I think the waiver of the passport requirement, you can do that through the 192, I think is the way that generally people do that. And then from there, I think that is something that if you do not have a passport, is a ground of inadmissibility that you would absolutely want to make sure that is waived. DHS can issue a kind of a form, which is in the form which is the DS-232, is a case in which like a visa is not being able to be placed in a passport. And so basically this is just kind of in lieu of that, which is kind of the issuance of a visa in the absence of a passport. And so it's a specific form that the Department of State can issue if you do have this lack of a passport. But sometimes it might be necessary for the client to seek custody. And to do so in the home country can be extremely time-consuming and really just logistically complex in terms of service of process and whether or not you can get someone to assist in this home country. And has anyone ever had to do this? I think that we can kind of talk a little bit about kind of the complications that can arise in this. But I'm curious to see if anyone has had to do this, either do any kind of custody proceedings or power of attorney so that minors could travel. And I see these other questions, and we'll definitely get to them on the end, but I want to kind of just take a moment about passports and travel. So generally, I think the question is whether or not the 192 waiver of inadmissibility should be filed with Vermont, and it should be filed with Vermont. Because if that waiver is approved, then all of that should go down to the consular level, and they should know about it. And so, unfortunately, Erica has a story that they tried to do it unsuccessfully. And then at that point, you need to look about what the home country laws are about the age of majority for travel, when they might be able to travel without a passport. But generally, sometimes you're able to get a power of attorney if the other parent consents, or other kind of document to allow minors to travel. Amy, do you have anything you want to add here?
Just to reiterate that point that you were mentioning earlier, that even if you can get the 192 or 193 granted, even if DOS is willing to issue this DS-232, that's only the U.S. side. There's still this issue of whether or not the home country is going to allow the child to travel, whether or not the home country is going to release the child, right, for international travel, which is oftentimes the more difficult part of all of this for minors. And then the other thing is, Cecilia, so you can waive the passport requirement on the 192 or the 193. Have you ever seen any difference in terms of, what one being preferable over the other, or does it really not matter?
I honestly have not used or seen a 193 in a hot minute. Usually I think that these issues can be addressed on the 192. If you look at the application for the 193, it basically says the purpose of the form is someone who is a legal resident of the U.S. to re-enter the United States without their passport or their visa. So I think mostly these passport issues can be addressed on the 192. I think it has been at least 4 or 5 years since the 193 has even come across my radar screen. So I think that is kind of how I have seen it, but I am very curious to see if people are just like low-key using this form, because I have not heard of it used in quite a while. How about you?
I haven't ever used it myself, actually.
Right.
But I had not heard that it was actually officially not being used before. I thought it was more like a general, most people are using the 192 because you're using the 192 for everything else anyway. Why not use it for the passport as well?
I agree, and I think that that is kind of the most context in which they're seeing it, because the 192 is specifically waiving grounds of inadmissibility. And so it seems like this 193, the purpose of the form seems to me a little bit different. As someone who's already a legal resident of the U.S. to re-enter without their passport. And so I think that there might be kind of special instructions, but I think that for the inadmissibility grounds that most people are using the 192 for the passport issue. But it gives it a little bit of history, kind of like kicking it back a little old school to the 193. Because that is something that they did set, at least in the outset when they created the forms, that they had wanted to see for passport issues. But I think generally speaking, because the 192 is for inadmissibility, that folks have been using that principally. All right. I-929. These I had mentioned before, which are for certain qualified family members for individuals who had never had U status. So Amy, if you had someone whose U3 status expired, right, and they never adjusted, could the principal then file 929 for them?
Well, no, because the U3 had U status all the way up until it expired.
Right. So these are not for those situations. It is not a second bite at the apple for individuals who had U3 status, right? This is for individuals who never had to be able to apply to become a qualified family member of U visa holders. And so what this 929 does is it comes into play once the principal applicant has adjusted status. And so this is a form so that certain eligible family members can effectively kind of, it's akin to the I-130 to be able to use this as a basis to be able to apply for their legal permanent resident in the United States. And so it is a certain family relationship, and in order to do this, you have to show that the principal is now an LPR or has a pending application for LPR status, that you have to prove that relationship, and that you have to prove that you or your relative will suffer extreme hardship if not allowed to remain or enter in the United States. And that you have to establish that discretion should be exercised in favor of your relative. And so this is very, very discretionary. For 929s, you're not going to need a 192 because all of it, inadmissibility issues that may arise, are going to be on discretion. So the eligibility. If the principal applicant is under 21, that's going to include your spouse and unmarried children under 21 and your parents. Notice that the siblings are not in this. So the U phase is actually more generous in that context for under 21 U visa holders. If the principal is over 21, it'll be spouses and children under 21 and unmarried who never had U visa status. And what's different about this is that this can't include after acquired spouses and kids. So after acquired meaning after the U visa grant, you can extend the benefits to spouses that you acquired between the time that the U visa was granted and the time that you are ready to adjust. We also talked about it's a remedy for people who have never had U visa status. But wait, Amy, I have a question. So I have a U visa derivative, right, who's 18 years old, right, and they have an approved Sup A, but they haven't consular processed in. Can I do a 929 for them if I'm ready to adjust?
Yes, because they've never consular processed, so they've never actually held U status. The approval of the 918A for somebody who's abroad does not grant U status, right? They don't actually get U status until they enter the United States and are admitted in U status.
Right. So that's a really important distinction, right? So if you have a Sup A that was approved and you're in the United States, then you have U status because you're in the United States. But for derivatives abroad, they are required to enter in with that status. So if you have someone with an approved Sup A who has never consular processed in, the 929 might be an option for them if they are still abroad and you're running into the time of the adjustment. But a really important part for this is that there is no age-out protection. So if you're doing a 929 for a minor child, you best get them here before they turn 21, because otherwise they are going to be out of luck. You can still kind of consider an I-130 down the road, but again, that is going to be very time-consuming and it's going to be really delayed. So which is why I think at the youth visa stage, it's kind of a more generous age-out protection than at the 929 one. And so Linda asked the question whether or not a principal can ever file a 929 for a sibling. And if you're under 21, no, you cannot. If you're under 21, you can file it for your spouse, unmarried kids, and your parents. Siblings are not included in the category of eligible family members for the 929 purposes. But if you are at the U visa stage and you're under 21, then siblings under 18 can be.
I also wanted to flag for the after acquired spouse and children. It should include after acquired spouses and children when they were acquired after the 918 was filed, not just after it was granted, right?
Right. Thank you for clarifying. Yes. That's an important clarification. All right. Okay. So we sort of talked about this already. And I think the only thing that I would actually mention before, that even though these applications are discretionary, that you should apply the same framework as if you were submitting an I-192 to address issues of inadmissibility, right? So I think that I would look at what would make it in the significant, in the national and public interest that this person remain here. And I think part of that is kind of the showing of hardship, right? Because oftentimes that's a factor, the FRANCA factors that they kind of throw at us in the D3 context is what is the hardship? And so I think building up those favorable equities and kind of showing kind of how this person is going to be important to maintain that family unity, to recuperate from the principal's applicant's victimization, and other kind of community involvement to negate any negative facts there might be in the record. So again, the 192, yeah, go ahead.
No, can finish up, and then I was just going to respond to one of the questions in the chat box. So.
Right. No, I was saying because it is purely discretionary, that you could make the same arguments as if you were to submit a 192, but one is not required. And so that makes these, I think, tricky applications because so much is riding on discretion.
Yeah. And we also have a question in the chat box from Sasha about how high is the standard for extreme hardship in the 929 context? What if there are no threats in home country, no emergency situation, no medical issues, and the children do have adequate caretakers in the home country? What basis can we use for extreme hardship? So the first place I would look would be the regulations. 245.24, there is a list of some factors that can be really helpful when you're screening for extreme hardship to walk through with your principal and also potentially with the 929 beneficiary. Sometimes the beneficiary may have some things that the principal doesn't even know about. So it's worth talking with all of the members who would be directly affected by this to see whether or not any of those factors would apply. But that would be the first place that I would look when you're assessing extreme hardship. Okay. I'm just trying to see if we have any more 929 questions before we move on here. Let me see. Okay, so I think we have some other U visa questions generally, but perhaps we can take care of those at the end, right? And then, yeah, okay.
Okay. Yeah, I just have one more slide, and then I'm going to turn it to Amy to have everybody's favorite ethics discussions, which I think is kind of a nice point to end on. So, the derivative rights in the United States, mazel tov. What do? For the U derivative, we would get them an A-20 work permit, which we would need to do because now that they are in the country, we would want them to have that kind of proof of status. And then we would help them adjust after 3 years of continuous physical presence. They might need an extension. Sometimes USCIS only grants a visa or entry or 194 for maybe only a year or 2 years. And in those cases where they don't have the full 4-year visa, you might need a 539 in order to do the extension in order to accrue the enough time to prove continuous presence in the United States. And we're seeing issues about what happens if you have your approved Sub-A, but nevertheless the derivative enters without inspection. I think that this is going to be something that we might get some more pushback on. So generally speaking, you know, if you're a derivative and you're approved, you should consular process in, right? But sometimes just life does not work out that way. And so in the past, I think what we would do is we would submit a new 192 for the derivative and then ask for that derivative to be placed in deferred action now that they are in the United States, or to kind of go through the process that way. Amy, what do you think about this?
Well, we've definitely been seeing more pushback in situations like this. So there have been RFEs, NOIDs, denials, where derivatives have entered without inspection after their Sub-A was granted. And so, for one, you always want to strongly encourage you and advise your principals and derivatives not to do this. Your principals should not be smuggling their derivatives in, and your derivatives should not be e-weighing. This is raising issues for principals, right, when there are indications of smuggling, and it's also obviously raising issues for derivatives as well. So there are some arguments that I would make in this kind of context. If you have a situation like this, please reach out to us for a TA. We're happy to help, but it is something where I think you can anticipate a pretty good amount of pushback from Vermont.
And would you say that that's the same in the VAWA context?
So I think it's a little bit different in the VAWA context because the derivative, in the VAWA context, if your only ground of inadmissibility is the illegal entry, the issue with the U is that you have to submit the 192 to waive the unlawful entry, right? Whereas in the VAWA context, the derivative arguably does not need to waive the unlawful entry. And so, you know, there wouldn't be a waiver requirement there.
Per se, right.
Right. So arguably, it's a little bit more straightforward, but I wouldn't be surprised if Vermont saw this as a negative discretionary factor, and it still raises smuggling issues for the principals in any case.
Right. And so I think, you know, in the section that effectively 212A6A1 is, you know, would not apply in the context of a VAWA self-petitioner, right? And so I think that we know that is to be true for the principals, and I think that the same logic would extend to derivatives. But I think, as you mentioned before, we're looking at it now in kind of a different world in terms of discretion. So I think it's important to kind of keep in mind, but it might be kind of a different ballgame altogether. And I can kind of put those memos in the chat box while you're covering the last and final and the best. Oh, we're not done yet. I thought we were. So here, I think we talked about this, kind of if derivatives overseas, advise them not to iwi, that you would file the new 192 addressing these grounds and request an amended approval notice. And again, as Amy mentioned, that this is an issue not only for the derivative, potentially also for the principal, and whether or not you would need to adjust their 192 or somehow amend their application if needed, if they're only, for example, on the wait list, to do some additional screening there if needed. And so, again, you shouldn't need to waive EV under 245A for VAWA self-petitioners, but again, to check whether or not there would be any smuggling issues for the principal applicant. And so those are something to kind of keep in mind if there's a VAWA derivative EW that is post-approval. And I will turn it to you.
Great. All right, so next up, we just wanted to cover some of the common ethical issues that can arise when you're dealing with principals and derivatives. And there are some particular issues that are more likely to arise in this context where you have joint representation, and also especially because a lot of derivatives are minors. And so there are obviously some special considerations when working with minor clients and incapacitated clients. All right. Okay, so let's say, going back to Susan and her family. So Susan's on the U visa wait list, and she arranges for Isabel to enter without inspection. And then they come in together and they tell you that, okay, now Isabel's in the U.S., and you say, all right, so I'm going to represent Isabel for her I-192 to waive this unlawful entry. And then later, you're talking with Isabel, and she tells you that her mother, Susan, is actually forcing her to provide unpaid child care to her brother, Kevin, and has threatened to get her deported if she refuses. And not only that, but Isabel doesn't want you to tell Susan what she has disclosed. So what are some of the ethical considerations that you identify from this scenario? Just in the chat box. So we're seeing conflict of interest, definitely. Loyalty, confidentiality, right? Conflict. Yep, there's probably a new inadmissibility ground for the principal for Susan for smuggling, trafficking also potentially. Right. So yeah, these are some of the common issues. This is maybe a relatively serious scenario in terms of the conflict, but it's not that uncommon for issues to arise in a family, right? No families are perfect, and so over the course of many, many years, as you're representing multiple members of the same family in a U visa, it's not uncommon for issues to arise and for conflicts to arise, for issues around confidentiality to arise and things like that. So we just wanted to look briefly at conflict of interest, confidentiality in joint representation, communication with joint representation, and also clients with diminished capacity. And obviously we're looking at the ABA model rules, but you'll want to consult your own state bar rules on these things to see how they apply to your situation. Conflict of interest is one of the stickiest issues that we see in principal derivative cases because we can't represent a client if the representation involves a concurrent conflict of interest, right? And so we're talking about situations where representing one client is going to be directly adverse to another, or where there's a significant risk that the representation could be materially limited by the lawyer's responsibilities to another client. And so here, what we're looking at is we have Isabel, who was brought to the United States by her mother and who's being forced to provide child care to her brother, right? And so we're potentially looking at human trafficking here. We're looking at a potential independent U visa for Isabel. We're looking potentially at a T visa for Isabel, right? All on the basis of her having been the victim of human trafficking by her mother, who is your principal client for the U. And so as an attorney, you have a duty to Isabel to advise her about her rights, about her eligibility for a U, for a T, about the requirement that she report to law enforcement, and that she cooperate with law enforcement. But you also have a duty of loyalty to her mother, to your primary client or your principal client, Susan, right, whom you're representing for this U visa, and who could potentially be adversely affected if Isabel reports her to law enforcement. There are cases where conflicts can be waived. This is probably a situation where it would be pretty difficult to waive the conflict here for the clients to really waive that conflict. And so typically where the conflict can't be waived, you're looking at a situation where you need to withdraw from both cases. And so this is one of the things where when I was in practice, I would always try to talk about what it means to have joint representation, what is conflict of interest, provide examples of conflicts, and explain the potential ramifications if a conflict did arise to clients at the outset of representation. This is something where it's a good idea to consider including it in your engagement letters, to have a really thorough conversation with clients when you're representing both principals and derivatives about the kinds of issues that can arise and what might happen if there is a conflict down the road. Okay. All right. Next up, confidentiality. So as people mentioned earlier, there is a confidentiality issue here, right? Because Isabel has asked you to keep this conversation private. She doesn't want you to tell her mother that she told you what Susan was doing. And the problem is that there are no secrets between joint clients on matters relevant to joint representation, right? This issue is arguably relevant to the joint representation. You're filing a 192 for Isabel for her entry without inspection, right? Her entry without inspection was brought about by her mother, who was potentially bringing her to provide forced labor. These are all details that would be relevant to her waiver of inadmissibility that it would be in her interest to disclose and explain on her 192 application. So this is probably not something that you would be able to keep from Susan as a joint client. It's also really important to keep in mind that privilege doesn't attach to communications between one client and the attorney if it's a joint representation matter. Okay. And this is also something to discuss with your clients at the outset of representation to make sure that they understand that if you're talking about issues that are relevant to the joint representation, that you wouldn't be able to keep secrets between them. And it's really important to tell them this at the outset so that you're not in a position of having to deal with it after the client has already told you something that they don't want you to tell to the other client. Another one that comes up sometimes is communication. As attorneys, we have a duty to communicate with our clients about decisions, circumstances where we need their informed consent, consulting with them about what their objectives are and how they want to accomplish them, and explaining things to our clients so that they can make informed decisions, right? But sometimes when you have joint representation, let's say you have a principal and 4 derivatives, and you're basically talking about the same thing with all 5 of your clients, right? Your principal and all of your derivatives. Do you really need to have this conversation 5 times? Well, potentially yes, right? Because each of your clients could potentially have different objectives and considerations and different things that they need to know in order to make a decision about their own case. And so it's something to really seriously consider as to how you're going to communicate about the case with your derivatives and your principal. It's probably safer not to go through your principal to communicate with your derivatives and vice versa. Of course, there are some exceptions, such as when you have clients with diminished capacity. So, for example, if you're looking at Kevin, communicate with them in a way that they're going to form consent, right? Very, very small children. With older children, let's say Isabel was 17, right, you would still have a duty as far as reasonably possible to maintain a normal lawyer-client relationship with her, right? And so to the extent possible, you're going to want to communicate with them as you would any other client. But especially with very, very young clients, you may need to talk with other people, such as their parents, who actually have the ability to make these decisions and take actions that protect the client and to act in the client's interest. Okay, and Melly, I'm seeing a question. Are there any exceptions for the duty of confidentiality if you're dealing with a domestic violence situation? I think I would need a little bit more detail there to know exactly what the domestic violence situation is and what the need would be to break confidentiality. Most states do have certain exceptions to the confidentiality rule. Some are permissive, where they'll say the attorney may break confidentiality if the client is expressing, you know, an intention to harm themselves or others. Other states will have a more shall type language, and there may be states that don't permit that. So exceptions tend to be very state specific, and it's important to look at the exact type of language in the rule to see, and in the comments, to see where exceptions are permitted, where they're required, and where there aren't exceptions. And Cecilia, did you have anything to add there?
Nope, I think that covers it.
Great. So, I mean, really the thing that I want to reiterate is that with any of these issues, and with really all client communications issues, and especially in joint representation situations, it's really critical to communicate with all of your clients about these potential pitfalls at the outset of representation. Typically, when we start a case, the family is united in what their goals are and feeling really hopeful about their future and what you might be able to do for them immigration-wise. But as we all know, over time, and these cases take a really long time, things change. Relationships change, family relationships develop, and conflicts can arise. Secrets can arise, and all kinds of issues can come up that nobody's anticipating at the start of representation. So for that reason, it can be really helpful to have a detailed discussion about this at the outset and put it all in writing. And sometimes when your client calls you and says, listen, there's something really important, I really want to talk to you about my mom, you can stop them right there and reiterate this discussion about conflicts and confidentiality and all of that before they tell you. It's a lot easier to avoid the issue if you tell the client what the issue is or what the issue could be versus trying to clean it up after the fact. All right. So I think that there were a number of questions in the chat box that we didn't quite get to.
Right, and I think some of those we can follow up with you offline, but we can get through as many as we can in the 6 minutes that we have. And so Erica asks, in the VAWA context, if the derivative EWE after the VAWA grant, but then the NVC has terminated the case, would you need to reopen the NVC case and adjust here? And I think in that case, I would, I'm putting in the chat box the link to the USCIS guidance that adjusts the adjudicator's field manual, which talks about VAWA self-petitioners who are present without inspection. And so what this memo effectively does, and if you kind of click on it, you could read, I think it is the second page, you know, it says that under Section 245A, that a beneficiary of a VAWA self-petition can apply for adjustment even if they're present without inspection or parole. Right, and so I think that that is something that, they're not required to kind of show hardship. So I think as a beneficiary of a VAWA self-petition, I would argue that that would be the case and to proceed with adjustment. But I think that definitely check in with us before you file. But that is the way that I would read that. How about you, Amy?
Yeah, I mean, that's how I would do it. But I wouldn't be surprised if we start to perhaps see a little bit more pushback on that.
I agree. I think that we've seen it in the U visa context. We've seen it in the T visa context. We are getting significant pushback. We're getting noise when this is happening. So I think that before you file anything for someone who is a VAWA beneficiary who entered iwi, please do check in with us because we want to make sure that we screen everything before we kind of say that this is definitely the way to go. That's how I have interpreted it, but I think I want to take a closer look. Any other questions you want to take in? So we have a question from Jacqueline about the U3 who entered the United States but never adjusted and then went back home. Can they be paroled under humanitarian parole application? I think that would really depend on the circumstances. I think that you cannot use parole to circumvent a legal immigration process. It has to be an emergency, humanitarian need, or significant public benefit. So if this person were required to provide testimony in a criminal case, or if there really is like a clear and present danger to them, then parole is a case-by-case adjudication. But again, I would caution that it not just be it's not supposed to be kind of a catch-all, cure-all for things. So I think that in this case, if you can kind of prove that there's an urgent humanitarian need, I see no harm in trying. But again, it's not meant to circumvent other legal ways of coming to the United States.
I would also keep in mind that parole is temporary. So just keep in mind that even if you managed to get humanitarian parole for this former U3, it's going to expire, and so they would want to have a plan, right, as to what they're going to do when this parole expires.
So Elizabeth asked, can you file the 921 and the 45 concurrently? Generally, you can file, in order to file the 929, the U applicant has to have adjusted or have an application for their adjustment pending. And so I think that you can file the 929 together with the principal's application for adjustment, right?
Yeah.
Amy, have you submitted them? And so I think that is kind of how I would consider it, the 929 together with the principal's adjustment, because I think you would need that filed and approved before you kind of do anything else. Is that your sense, Amy?
Yeah. If you look at the regulations, you would need the approval notice from the 929 in order to file the 45 for the derivative, for the 929 beneficiary. Yeah.
Yeah. Always a good idea to take a look at those. All right, well, we are at the hour. I want to thank you all for listening in. Please do contact us with questions that you might have. This is how to reach us. This is how to get technical assistance from us. We appreciate your time and hope you have a wonderful rest of your day. Thank you, Amy, and thank you, Alicia.
I also just wanted to flag very quickly, I know that there are some questions that we didn't get to, so they're going to be sending us a chat transcript. If we have your contact information, we can try to reach out to you that way. If we don't get to you, then, or even in the meantime, if you want to submit a technical assistance request, then we can talk about it that way too.
Great. Thanks so much, everybody. Have a good day.